Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone. In this episode, I am going to talk about the new governance rules for defined contribution schemes, more commonly referred to as DC schemes. You may remember that the Department for Work and Pensions was consulting on improving outcomes for members of DC pension schemes and incorporating performance fees within the charge cap. On the 21st of June, it published its responses to these two consultations, as well as draft regulations to give effect to proposed measures. The regulations are called the Occupational Pension Schemes, Administration, Investment, Charges and Governance Amendment Regulations 2021. So very catchy. I'm just going to refer to these as regulations in this episode. I'm going to summarise the key new requirements which these regulations, which are due to come into force on the 1st of October 2021 this year, like many other obligations coming into force on that date, will introduce. So to start with, trustees of all relevant pension schemes, whether the scheme is big or small, will have to calculate the return of investments from their default fund and self-select funds, net of transaction costs and charges. Just by way of reminder, a relevant scheme is a money purchase scheme, unless exempt, and does not generally include a defined benefit scheme where the only DC benefits are additional voluntary contributions. This information must be stated in the annual chair's statement for the first scheme year ending after the 1st of October 2021 and published on a publicly available website. Trustees should look to show net returns dating back 5 years or to the start of the pension scheme if that is a later date. If the figures cannot be provided because the data is incomplete or it's just not available, then trustees need to make members aware of that in the chair's statement. I will move on to the value for members assessment now. From the first scheme year ending after the 31st of December 2021, so New Year's Eve, trustees of schemes with less than 100 million total assets which have been operating for at least 3 years will be required to carry out a more detailed value for members assessment. It's worth noting that while all the scheme assets, whether they relate to defined benefit or DC element of a scheme, are relevant when assessing if this requirement applies to a scheme, if the requirement does apply, it only applies in respect of the DC element of the scheme. This new obligation will require trustees to compare reported costs and charges and fund performance with 3 other schemes and consider key governance and administration criteria. I will cover each of these requirements in a bit more detail shortly. Before I do though, I just want to note that the outcome of the assessment must be explained in the annual chair's statement and published on a publicly accessible website. The outcome must also be reported to the pensions regulator via the annual scheme return. One final general point to make is that if trustees have told the pensions regulator before the next chair's statement is due that the scheme is winding up, the scheme will be exempt from this detailed value for member assessment requirement. I'm going to talk a bit more now about the factors to be taken into account when completing the value for member assessment. The starting point is the 3 comparator schemes. Trustees must ensure that any comparator scheme satisfies the necessary criteria and should have a clear rationale for why they've chosen a particular scheme as a comparator scheme. The key criteria of a comparator scheme are that it is an occupational pension scheme which on the relevant date held total assets equal to or greater than 100 million, or a personal pension scheme, and at least one of the three schemes has had discussions with the scheme seeking to comply with the new value for member assessment requirement about a transfer of the member's rights in the compliance scheme. Moving on to the costs and charges, as mentioned, the compliance scheme has to compare its costs and charges with the other schemes. As well as taking account of the pensions regulator guidance, there is also statutory guidance on completing the annual value for members assessment and the reporting of the new investment returns, which provides some helpful insight into the costs and charges analysis. Although the regulations do not bring in any new requirements regarding disclosure of charges and transaction costs, trustees might want to consider building on the existing disclosures by providing anonymised costs and charges data from the three comparator schemes. With regard to the new investment returns, trustees are expected to place more weight on the performance of their investment returns over costs and charges. This is mainly because value is not just about costs and charges. Value for members is about seeking to obtain value for money for the membership rather than the lowest costs, having taken into account the characteristics of the membership, such as demographics and salaries. Trustees should compare net performance investment returns in the short term, so over a 1 year period, as well as the long term, so over 5, 10, 15 years. The final point to note on net investment returns is that short-term underperformance is unlikely to be an indicator of poor value, whereas long-term underperformance is. I mentioned earlier that when undertaking the new detailed value for member assessment, trustees will also need to consider key governance and administration criteria. This assessment will be carried out by considering the scheme itself. Where functions have been delegated to third parties, the trustee still remains responsible, so these functions should be clearly and regularly monitored. There are 7 criteria for trustees to consider when considering this limb of the new value for member assessment. These are 1. Promptness and accuracy of core financial transactions, which includes all key payments into and out of the scheme, such as the attribution of contributions to the relevant funds. 2. Quality of record keeping. 3. Appropriateness of the default investment strategy. 4. Quality of investment governance. 5. Level of trustee knowledge, understanding and skills to operate the pension scheme effectively. 6. The quality of communication with scheme members. And finally, 7. The effectiveness of management of conflicts of interest. The outcome of the assessment should be reported in the annual chair statement, which, as I'm sure you all know, needs to be published on a publicly available website, as well as in the annual scheme return. If, after completing the assessment, the trustees conclude that the scheme does not provide value for members, the trustees should look to wind up the scheme and transfer the rights of their members into a large occupational pension scheme or personal pension plan, or, alternatively, set out an immediate action plan on how they're going to make improvements to the existing scheme. The regulations also make some other changes to current requirements, such as, on and from the 1st of October this year, trustees will be able to smooth investment performance fees over 5 years for the purposes of the default fund charge cap, and wholly insured schemes are excluded from the requirements to include information on the trustees' policy on asset managers in their Statement of Investment Principles, or SIP. Wholly insured schemes typically have very little discretion over how to invest their assets, and so generally they're exempt from producing most sections of a SIP, and this change just reflects that reality. I think these changes, while imposing some additional requirements on trustees, seek to drive up governance standards of DC schemes and improve outcomes for members, so they will be widely welcome. Thank you for listening. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.